5 seconds to go. Start. This appeal is filed against the impugned order dated 28th March 2022 passed by the High Court of Judicature at Bombay in a criminal interim application number 1945 of 2021 in a criminal revision application. Brief facts necessary for disposal of this appeal are that a complaint was filed on 21st January 2002 by one Shri S. Gurumurthy with the Securities and Exchange Board of India, for short the SEBI, against Reliance Industries Limited, for short RIL, its associate companies and its directors, alleging that they fraudulently allotted 12 crore equity shares of RIL to entities purportedly connected with the promoters of RIL, which were funded by RIL and other group companies in 1994. It was alleged that the company and its directors were in violation of Section 77 of the Companies Act 1956. Based on the aforesaid complaint, the SEBI appointed an investigating officer to inquire into the aforesaid complaint. Accordingly, a report was submitted by the said investigating officer on 4th February 2005. It may be necessary to note that SEBI chose not to take any action with respect to the aforesaid letter. The appellant alleged that a note was prepared by the Legal Affairs Department of the SEBI on 17th March 2006, wherein it was noted that the report had not brought out any specific violation of any legal provision by RIL. However, the note was said to have observed that there was requirement of an opinion by an external expert inter alia on the possibility of initiating appropriate criminal proceedings against RIL. In this context, a retired judge of this court, Justice Retired B.N. Shri Krishna, was approached by SEBI for the same. The learned retired judge is stated to have given his first opinion to SEBI, which was divulged by SEBI in parts to the appellant herein. On 16th April 2010, SEBI sent a letter to RIL alleging that RIL had funded purchase of its own shares by 38 related entities and thereby violated Section 77(2) of the Companies Act 1956 and consequently violated Regulations 3, 5 and 6 of the Securities and Exchange Board of India prohibition of fraudulent and unfair trade practices relating to securities market regulations 1995. RIL in reply addressed numerous letters to SEBI requesting for copies of the documents and submitting inter alia that the issue concerning violation of Section 77 of the Companies Act 1956 was examined by the Ministry of Corporate Affairs, which had concluded that the transaction was compliant with the applicable law. In any case, the adjudicating officer of SEBI issued a show cause notice to the promoters of RIL under Rule 4 of the Securities and Exchange Board of India procedure for holding inquiry and imposing penalties by adjudicating officer rules 1995, alleging violation of Regulation 11(1) of the SEBI takeover regulations as it then stood. It is borne out from the records that an office memorandum dated 18th July 2011 was issued by the Ministry of Corporate Affairs, wherein it was noted that provisions under Section 77 of the Companies Act 1956 was not attracted. Stop.